Welcome to Law Sessions. I am Jennifer Housen. In this session, we will focus on the land law principles of leases and licenses. And in a later full-length lecture, we will consider leasehold covenants. We will start with licenses, and then we will consider leases in depth in this lecture. Now, over the next hour or so, we will see what constitutes a license. We will also see what constitutes a lease, and we will see the determining factors which differentiate a lease from a license. If we consider licenses first then, and what the definition of a license is, a license is no more than permission for someone to do some act which would otherwise be unlawful in regard to the land of another person in the absence of that permission. So license simply means permission. What having a license does is that it prevents what would otherwise be a tort, for example, trespass, and therefore having a license means, of course, that you do not break the law. A license, of course, lacks the qualities of an interest in land, and that, of course, as we will see later on, is one of the main distinctions from a lease. So it does not give you an interest in land, it is not transferable either, and it will not be enforceable against a third party. Now, there are different types of licenses. So, for example, you can have a beer license. So, for example, when one party gives another party permission to do something on his land and there is absolutely no consideration, something you would have learned in contract law. So if there's no consideration or payment between the parties, you are more or less looking at a beer license. You are taken to have given, for example, the postman permission to walk up to your driveway to deliver your mail, or for people to play in a field or to camp. These, of course, are beer licenses because they lack any sort of consideration for the use. Now, in order for you to revoke a beer license, if, for example, you're the landowner, you must allow a reasonable amount of time for the person to leave. Now, if the person doesn't leave after this time, he will become a trespasser, and of course, reasonable amount of time will depend on the circumstances. The point, of course, is what amounts to reasonable time will depend on what it is the person is on there doing. So if the postman, for example, is coming to your door, reasonable amount of time is going to be the time he takes to drop the letter through your letterbox and walk back down your path. Whereas if somebody is staying in your house, for example, it would take the amount of time for him to pack his clothes and personal effects and leave, which might, of course, be a couple of hours or so. Of course, if you look at a contractual license, which contrasts with a beer license, this is where consideration or value is given for the license. So, for example, when you pay for a ticket to watch a film, or you pay to stay in a hotel, or you pay to stay in a car park, all of these are contractual licenses. Now, a person who occupies land but cannot satisfy the requirements for a lease will, of course, have a contractual license. And what I mean by that is when we look at leases and we see what the requirements are for a lease later on, if any of those requirements is missing, then the person, precisely because he cannot meet the threshold for a lease, will have no more than a contractual license. Now, historically, at common law, a contractual license could be revoked at any time. The case for that, of course, is Wood and Ledbetter, an 1845 case. And it said that a licensee had to leave whether or not he completed what he was given permission to do on the land, and the landowner, of course, could claim damages for breach of contract. Now, if he fails to leave, he's a trespasser. Now, I know I've raised before that if someone doesn't leave land, then he becomes a trespasser. I want you to draw a distinction here, because for the vast majority of you, you will have completed, of course, criminal law. And if you remember in criminal law, and in particular burglary, when you looked under Section 9 of the Theft Act in relation to burglary, the point is that you could not become a trespasser in the criminal law if you were already on land. But that is not the same in land law, because you could be legitimately on premises, but then subsequently become a trespasser. And that is the point. You could give somebody permission to do something on the land, but you could revoke that permission in the middle of whatever the person was doing then and there. Now, the assigning of the benefits of a contractual license is only possible if it is permitted by the contract. If the contract expressly prohibits any assignment, it cannot be done. So that means that if you allow somebody who has a contractual license to be able to pass it on to somebody else, for example, then that's fine. But if the contract does not provide for there to be an assignment, for it to be passed on to somebody else, then certainly it can't, and may very well give rise to a situation where you would then be entitled as the landowner to revoke the license. If the nature of the license is personal, then by and large it tends not to be able to be assigned, because it is similar to sort of a contractual a contract of a personal nature, where you cannot assign in the absence of the person who has contracted to do the particular obligation. Now, the effect of a contractual license on a third party is that traditionally it has not been seen as a proprietary interest. And the case of that, of course, is King and David Allen and Sons. And that's a 1916 case. However, interestingly, a case that you would have touched on in contract law, Errington and Woods. And if you remember, that was the case where Lord Denning famously found that once you have started performance in a unilateral contract, then of course it couldn't be revoked. That was the case. But the point from Errington and Woods was that Lord Justice Denning, as he then was, claimed that a contractual license, or a contractual license given to somebody on the land, was a proprietary interest in land, and so it could bind a third party. Now that, of course, went against what the historical position was. What I want you to take on board, of course, however, is that in a later case, Ashburn, Anstalt and Arnold in 1989, it was held that Lord Justice Denning's decision in Errington and Woods, as it related to that point that a contractual license was a proprietary interest, was actually per incurium, which means that it was decided without taking into account the correct law, basically. And so Ashburn and Anstalt said it was not a proprietary interest. Now, what about a license coupled with a grant of a property right? Now, this is an interesting phenomenon, because it exists when a property right is granted by, let's say, A to B, which allows B to go onto A's land to exercise the right. Example, a sporting right or a profit pronde, which means, for example, that I allow you to come onto my land, for example, to pick apples, which you're then going to sell. You exercise the right, which is the license, the permission to come on my land, but you get a profit, which is a right to take some sort of interest from the land. Now, what if the land is used in such a sense where, for example, there's a property right? Well, the position that I'm considering here is a proprietary interest as it relates to proprietary estoppel. We have had a recent case, well, when I say recent, I'm looking at 2006, in Cobb and Yeoman's Row Management Limited. What we had there was that the parties reached an oral agreement in principle under which Yeoman's Row Management would sell land to Cobb for development. The agreement, of course, was void by virtue of Section 2 of the Law of Property Miscellaneous Provisions Act 1989 because it was an oral agreement to do with land. However, as Cobb had spent a considerable amount of time and money in applying for planning permission in the belief, encouraged by Yeoman's Row Management Limited, that the company would honor the agreement, then the court said a proprietary estoppel equity arose in Cobb's favor. This was a separate and distinct cause of action based on the unconscionable conduct of Yeoman's Row Management Limited, and Cobb was entitled to a remedy. So, a license then is only permission, which is terminable at will as it has no proprietary interest. However, I would ask you to contrast that with a lease, which does. Now, a lease, before we get into the depth of it, if we just consider certain terms and definitions, then I want you to take on board these terms and definitions as we go into looking at lease proper. Now, a lease is sometimes referred to as a demise, and the premises, of course, in question is the demised premises or the premises demised. The term tenancy is normally used for interest lasting for a relatively short period of time, while lease will usually indicate a more enduring interest, so a longer period of time. So a lease will normally be the generic term, which will also include a tenancy. The grantor of a lease is known as the lessor, and the person to whom the lease is granted is the lessee. On the grant of a lease, the lessor retains what is called the reversion. So because you own the property, so let's say you own the freehold, then it would be considered a freehold reversion. And of course, the person who owns the property could, of course, assign the reversion or the freehold reversion. So as he owns the freehold, or let's assume he owns a leasehold, if he owns a leasehold, it is termed a leasehold reversion. So if you're leasing, then leasehold reversion. If you own, a freehold reversion. Now, instead of assigning the lease, so instead of transferring the property for the whole of the period for which it is held, the owner of the lease may, of course, grant a sublease or an underlease, as it is sometimes called. Now, I've flagged up assignment and sublease. Where you assign, you more or less give the other party all of your remaining rights in the property. I will, of course, explain this when we get to the leasehold lectures. But an assignment is where you give all of your remaining rights in the property. Whereas a sublease, you give only part of your rights in that property, and it will revert back to the lessee at the end of the sublease. Now, the parties to the sublease, of course, become the sublessor and the sublessee. So you could legitimately have a situation where you have a landlord who leases to a tenant. The tenant then subleases to a sublessee. The tenant now stands in the position of not only a tenant, but as a sublessor. Now, where the original lessor and the original lessee have both assigned their interest, the new owners of the reversion and the lease generally take the title of lessor and lessee. But for ease of reference, I would suggest that you keep these expressions for the original parties to the lease and then refer to the owners for the time being, whether the original or whether the assignee, as the landlord and tenant. Now, we will take a short break, and when we return, we will continue with leases and licenses, and in particular, we will consider what constitutes a lease.